Yes, Mr. Bruce.
Thank you, my lord. Just and convenient and discretion, the point that
Yes.
my lord, Lord Justice Popplewell raised just before lunch. I think that our answer to that goes back again to Respondents lines. Perhaps if we look at a few more of the relevant paragraphs, that would help. So we looked at, in context, at paragraph 68. The starting point is the identification of the policy, the important policy, where contractually agreed forum is arbitration. Policy of securing compliance with the parties' contractual bargain is further reinforced by the strong international policy of giving effect to the to agreements to arbitrate disputes. Moving down then to paragraph 71 on the same page, bottom of 71, Lord Legate said that if the parties had chosen an English seat of arbitration, the English court would not hesitate to enforce the parties' bargain by issuing an injunction to restrain a party over whom it has personal jurisdiction from commencing or continuing foreign proceedings in breach of the arbitration agreement. That observation was in the context of the court there dealing with the different situation of a French seat. He then, picking it up from B, section B, and referring to Lord Justice Millett's comments in Agaliki, said that he observed there that while such an approach has much to commend it, where an arbitration is sought on the ground of forum convenience, there is no good reason for diffidence in granting an injunction to restrain foreign proceedings brought in breach of an arbitration agreement on the clear and simple ground that the defendant has promised not to bring them. As Lord Justice Millett further explained, the justification for granting of the injunction is that without it, the applicant will be deprived of its contractual right in a situation in which damages are manifestly an inadequate remedy. The jurisdiction is, of course, discretionary and is not exercised as a matter of course, but good reason needs to be shown why it should not be exercised in a given case. So stepping back, if you've demonstrated a breach, yes, of course, you're still in discretionary territory, but there is a very strong presumption that the discretion will be, in an anti-suit injunction case, exercised in support of forcing compliance with the arbitration agreement.
This is all in the context, isn't it, of having established jurisdiction over the defendant?
Yes, so I am addressing your lordship's point on the basis that we established jurisdiction, and forgive me if I misunderstood your lordship's point before lunch, but assuming that we established jurisdiction under the in respect of a contract gateway.
That was my point. My point was,
I misunderstood.
Are we jumping straight to that, or is there a question that I'm not sure I've seen addressed so far, which is, once you're through the gateway,
yes,
on in respect of, is it a proper case for granting leave to serve out? Because your arguments on ground 2,
yes,
tended towards you don't have to worry about whether it's a 1 contract or a 2 contract case.
Right.
That's all taken care of.
yes.
Deal with the degree of connection when you come to
yes,
is the proper case for service out.
yes.
And my concern was, at the moment, as illustrated by what you've just confirmed, you're past that stage of the argument and you're just addressing whether it's just and convenient, assuming that the defendant is properly before the court, which is what the assumption is in this case. What I wasn't sure about is whether there is any part of your argument that will address whether, if you're right about in respect of, it is nevertheless a proper case in which to grant service out over AO.
So let me deal with it in the context of in respect of, assuming that we show that this is a contract in where the ASI claim is in respect of a contract.
The facility agreement. Yeah.
Assuming we showed Yes, your lordship needs to consider nevertheless whether it is a proper case to grant an injunction. In considering, however, whether in the context of an in respect of jurisdiction, it is a proper case, the relevant factors are those that are identified by the Supreme Court in Rustem Alliance and UniCredit, where they say you don't need to consider whether or not another jurisdiction has a closer connection to the anti-suit injunction case. The overriding consideration in proper forum context is the importance of securing compliance with an arbitration agreement. And of course, Global 500 wasn't an arbitration agreement case, so we didn't have those policy issues. So that is the fundamental factor, securing compliance with an arbitration agreement. And in the vast majority of cases, that would make England, as long as it's got jurisdiction, the proper jurisdiction to grant anti-suit injunction relief. Now, what Lord Millett, in fact, Lord Leggett, then identifies as potentially relevant in D, so D on page 557, which you were just looking at, are issues such as delay in applying for an anti-suit injunction, or the fact that the applicant is submitted to the jurisdiction of the foreign court. Those are the potential discretionary factors in an anti-suit injunction context that may be relevant and may sway the discretion element of it the other way. But in an anti-suit injunction element, aside of those things, the importance of securing compliance with an arbitration agreement is the prevailing factor, is the prevailing discretionary factor.
So your submission is that the relevant factors that go to whether it's just and convenient in a case where you have personal jurisdiction are the same considerations that apply as to whether you do have personal jurisdiction for the purposes of the proper, whether it's a proper case for service.
Yes, exactly. So
does that mean that in an anti-suit injunction case, the proper case test has nothing to do with connection with this jurisdiction?
Certainly forum convenience has nothing to do with it. That's clear from UniCredit. And I'm talking from Rustem Alliance, from the Rustem Alliance case. That's what the
I mean, the gateway that gets you, or the gateway through which you go in order to satisfy that part of the jurisdiction test may not be English law. It may be something with very much less connection with England. But nevertheless, if it's an anti-suit injunction case, the supremacy of arbitration gets you home not only on the merits but
and for discretion
before that on proper case
forum discretion
service out of the jurisdiction.
Yeah, exactly.
That's what you say.
Yes, absolutely, and I say that's clear from Rustem Alliance. I'll see if there are any other. That's what's made clear, certainly in terms of proper forum convenience. The fact that is not relevant in an anti-suit injunction case is what we looked at in paragraph 75 of Rustem Alliance on page 606. We looked at that just before lunch, and the reason for that. The reason for enforcing an arbitration agreement as being the primary factor is precisely my Lord Justice Popplewell's comment in Enker, which the Supreme Court picked up and referred to here, that in principle it's desirable that the parties should be held to their contractual bargain. That's the overriding factor on discretion, on just and convenient as well. And then, perhaps just to emphasise the point, if we can look at page 564.
I think our page numbers may differ from yours. So what paragraph are we looking at?
I'm sorry, page 98.
Paragraph 98.
I'm sorry, paragraph 98, yes. Which should be about 4 or 5 pages. And so if we just pick it up at the bottom of the page, section H, Lord Leggett says there, the only question is whether the English court can and should exercise their coercive power to enforce them, the arbitration agreement, by restraining Rustem from continuing the Russian proceedings, this being a French-seated arbitration. This is not a supervisory function which ought therefore to be left to the courts of the seat. The role of the court of the seat is to supervise the arbitration itself. They are not the only court that can prevent a party from breaking its contract to arbitrate, i.e. forum convenience, again, emphasising is not the relevant factor. Then 100, the fact therefore that in relation to any arbitration agreement which may in future be brought, the parties have chosen to be subject to the supervisory jurisdiction of the French courts is not in itself a reason why an English court cannot and should not uphold the parties' bargain to by restraining a breach of the arbitration agreement. And to demonstrate just quite how powerfully the importance of compliance in an arbitration context is, if we look over the page at 104, Lord Leggett makes the further point that even if the French courts were an available forum, there is no reason which can be said to make it inappropriate for an English court to restrain a breach of the arbitration agreement by granting an injunction. The fact that any arbitration brought would have its seat in France does not amount to such a reason.
But that's all because, if I go back to 83, what's led up to 83 are the passages we've been looking at, which are all premised on the court having personal jurisdiction. And then what Leggett says is 83. It's unnecessary to express a view on whether it will always amount to a decision that the English court has personal jurisdiction. And it says that may not be so, but in this case, last two lines, there's a substantial connection, which is the fact that the arbitration agreement is an English law arbitration agreement, and so the court is being asked to enforce the contractual rights which are governed by English law.
Yes.
That's all on the basis, A, there is personal jurisdiction. That is the starting point. Even in those cases, usually you'll do it, but not always. And this is a case where actually you're enforcing the English law contract. But none of what was said in this case was addressed to whether the English court should be the court assuming personal jurisdiction.
Well, the question of whether
It is whether,
yes,
when it has personal jurisdiction, what are the factors about whether it's just and convenient to actually grant the anti-suit relief?
so is your lordship's point that there's a difference between just and convenient and should, as opposed to we've got it, now should we?
My point is there's a difference between deciding whether you should assume jurisdiction over the defendant and deciding whether you should grant relief against them. The second of those is what this case is concerned with.
The assumption
of them is what is concerned with the is what Part 6 is concerned with.
the assumption of jurisdiction in our case, we say, is made out under the in respect of a contract and under
It's
necessary.
only half of it. The in respect of gets you through the gateway.
Yes.
That doesn't get you all the way home on jurisdiction.
So we're back to the issue.
That's what all I'm putting to you is that, as you can tell, I'm not getting much out of this case that helps me with your submission that once you're through the gateway, then you romp home on proper forum, simply because everybody should be interested in enforcing arbitration agreements, and therefore this court should assume jurisdiction over this defendant in order to enforce it.
Well, the last point that that the Supreme Court made, which is at page 567, paragraph 108. was a position of fundamental justice. I'm picking it up, substantial justice, I should say, just below C. The more fundamental reason why substantial justice could not be obtained through arbitration proceedings is that any award or order made by an arbitrator has no coercive force. It is not backed by the powers available to a court to enforce performance by its orders, which include sanctions for contempt of court. An order made by an arbitrator creates only a contractual bargain. So what we would say, what the Supreme Court, Lord Legate, was focusing on here, that ultimately, is there a reason of substantial justice why the English court should step in where the seat of the arbitration is not England, it's another seat, and if the position is that no other forum can provide proper interim relief, and it's not suggested that there is another forum. We had Austrian law advice, for example, to that effect. Then that is the reason why it is proper for the English courts to exercise its power and its jurisdiction. Thank you. So in addition to his lordship's conclusion that this was a case that was overwhelmingly Russian, which you say is not relevant, the other point that was made, or another point that was made as to why it would not be just and convenient to grant interim relief, was an antecedent injunction. There was no reason to believe that if an antecedent injunction was granted against AO, SPA would continue the Moscow proceedings itself, or AO would ignore the anti-suit injunction against it on SPA's instructions. So this is just and convenient specifically in relation to SPA. Now we say that that conclusion was, with respect, illogical and counterintuitive because it was based on a premise of an anti-suit injunction being granted against AO and therefore being sufficient to protect Fashion House's interest in circumstances where the judge was not proposing to grant such an anti-suit injunction at all. So that was not a relevant, just and convenient consideration, we say, for indeed a logical one for the judge to take into account. And then the third reason under just and convenient that the lordship gave was the motive point, that he considered it to be, considered the reason for Fashion House applying for an anti-suit injunction against SPA to acting as an anchor defendant. We say that's not a relevant factor either because of the strong presumption that if one shows breach, that in itself is a prima facie, very strong justification, prima facie justification for granting an anti-suit injunction absent good reasons. And this is not a good reason in relation to motive. But more importantly...
Motive went to the necessary proper party claim.
Yes, it did.
What do you say is the real issue between you and SPA, which the English court needs to try, even if AO is not there?
But in relation to the anti-suit injunction, the issue of an anti-suit injunction against SPA, is that the point?
No, well, they're not breaking the arbitration agreement. They weren't even parties to the Moscow proceedings until you brought them in, as I understand it.
They are in breach of the Moscow proceedings for the following reasons. I'm sorry, a breach of the arbitration agreement by what's occurred in the Moscow proceedings and the bringing of the Moscow proceedings for the following reasons. Firstly, AO has brought those proceedings as agent for SPA. One of the debts, in fact, I think it's the principal debt that is being enforced in the Moscow proceedings is the debt that is owed by Fashion House to SPA, not AO. That is the Euro debt. Your Lordship will have picked up that there are two facilities under the facilities agreement: Euro facility, a loan extended by SPA, ruble facility, a loan extended by AO. So these are Moscow proceedings brought on behalf of SPA by its agent. That's point number one. Point number two is we say, and the evidence for this is set out by His Lordship in paragraph 70 to 71 of his judgment, that the proceedings were brought entirely on the instructions and at the instigation of SPA. I think that Mr. Simpson has handed up to your clerks just a very short note of where you will find the evidence for this. This is just as an aid memoir, if your Lordships find it helpful. But the actual evidence, if your Lordship wishes to look at it, it's set out in comprehensive form at paragraph 70 to 71 of the judgment. But it is copious. That SPA has been pulling the strings is glaring from the evidence. Apart from the fact, first and foremost, that the big debt that's being enforced is SPA's debt. The idea that it's not been, it's not done at SPA's instigation is fanciful. There were negotiations about an extension of the ruble debt owed to AO at SPA's headquarters in Milan. There are emails in which AO says that any payment proposal by Fashion House has to be cleared, including the ruble payments, has to be cleared by SPA. And the Moscow proceedings were brought because on the email evidence of AO, SPA had said, we're not accepting any more payments via ruble. So the evidence is all there that the Moscow proceedings are brought because SPA has asked it to be brought, has asked AO to be brought as agent. That's a breach. That's a clear breach by SPA. And the final piece of evidence, and we say the overwhelming, the one that stands on its own, is that my instructing solicitor set out at the very outset in evidence his view that this was what was happening, that SPA was instigating and controlling. That has never been challenged. That has never been challenged. In any of the four witness statements that UniCredit has served, it's not been challenged in their witness statement, it's not been challenged in their skeleton argument, it's not been challenged in oral submissions below, and it's not been challenged in the skeleton argument for this appeal either. The only point that's being made is that AO has its own board of directors. But what is conspicuous in that explanation from UniCredit is any statement that that board has in fact been acting independently of SPA, and that that board has in fact decided, or did in fact decide, to take the Moscow proceedings, to continue it, to prosecute it without influence or instructions from SPA. It is perfectly clear what's going on here. SPA is in control, SPA is in breach. The fact that
the only pleaded breach I could see in your claim is a breach by AO.
Well, I have to look at the terms of the claim form, but we have put our case very, very clearly in evidence below, and for this appeal, that there is a breach by SPA because it has controlled these proceedings. These proceedings have been brought at its instigation. They are in breach of an arbitration agreement to which it is a party. That is a clear breach. That's always been how our case has been put. Never been any dispute about that. So I want to deal very quickly with the point raised in the respondent's notice as to whether the jurisdiction under CPR Part 6 applies at all to arbitration claim forms. I should say the jurisdiction to serve out applies at all. These are the Rule 6.36 and Practice Direction B, paragraph 3.1 gateways. Now, it's said against us in the respondent's notice that the court doesn't have jurisdiction to grant service out for an arbitration claim form under any of the Part 6 gateways. And we say that's wrong for the following reasons. Firstly, there's clear statement in both Usk-Menigorsk, Supreme Court decisions in Usk-Menigorsk, and UniCredit that such an existence, such a jurisdiction exists. I think it was in UniCredit itself where the court specifically considered 62.5 and I'll give you the reference very quickly. From 91 to 93, it considers the ambit of 62.5. But nevertheless concludes that there is a gateway available under the in respect of a contract provision. And then in Usk-Menigorsk, which lordships will find at tab 12. Paragraph 51, page 323 of the authorities fund. Lord Mance said, I add only that in the present case, although leave was in fact obtained under paragraph 3.12 of the Practice Direction 6B and CPR 62.51B and C, the court would appear also to have had jurisdiction to give leave for service out of the jurisdiction under paragraph 6.16C of the Practice Direction 6B on the grounds that treating the arbitration agreement as a contract, the claim was made in respect of a contract where the contract is governed by English law. So what we see there is Lord Mance considering 62.5 directly and making the point that the Part 6 gateways are complementary to those of 62.5. Now, the respondents' arguments to the contrary, apart from being inconsistent with those two Supreme Court decisions, is based on Rule 6.1. You will just find a copy of it. It's Charters Bundle 621. And the fact that 621 reads, this part applies to service of documents except where another part makes different provision. And cites as examples Part 54, Part 55, but not Part 62.
This is 6.1, is it?
6.1. Yes, Lord. Second half of page 621. Now, the point made by UniCredit is that 62.5 makes a different provision and excludes the Part 6 regime. But that's wrong, not just because of the Supreme Court decision. We respectfully submit that different provisions.
I may have different page numbers from you. I've got Part 6,
Yes.
page 598.
Yeah.
It's 6.1A we're talking about, isn't it?
Yes, I'm sorry if my
Just
numbering
you
has
get
gone
referring
wrong
to
for some reason.
621, right?
Yes, I'm sorry if my numbering's gone wrong. If your lordship has the beginnings of the section on Part 6, in fact, I think it's the section on CPR rules. It's the fourth.
Part C of the bundle, tab 1.
Yes.
Yeah.
6.1A, is it?
Yes.
any other enactment or practice situation makes different provision.
Different
That's-
provision.
That's the critical phrase.
Different provision is the critical phrase. That's right, my lord. Well, we say, read purposively and consistent with the Supreme Court's decision, different provision means inconsistent provision, and it doesn't apply to a provision which is complementary or which adds to the Part 6 rules. We see that from the examples given of Parts 54 and 55, which each contain mandatory service rules unrelated to service out, I should say, that are inconsistent with Part 6. And there's no inconsistency between Rule 62.5.2 and anything in paragraph 3.1 of Practice Direction 6B. And we say you can test that by standing back, and if the respondents were right, you would reach this startling conclusion or startling omission. The court would have no jurisdiction to grant an anti-suit injunction in support of a foreign seated arbitration solely because its power to do so arises under sections 37(1) of the Supreme Court Act, whereas it would have jurisdiction to grant other interim relief in support of a foreign seated arbitration simply because that arises under section 44 of the Arbitration Act and is recognised expressly in Rule 62.5b as being a gateway to jurisdiction. And there will be no policy justification for that disparity in the court's powers. So that's another reason. The fourth is we rely on Rules 60.3a. Forgive me, it does look as though my numbering has gone awry, but it's, I think, 3 pages on. It should be 3 pages on from where we were looking at in your bundle. Top of the page, 630. Do you have that?
630.
Yeah, 6.30.
Top of page 601 for me.
601, thank you. Sorry, when I say 630, I mean the rule 630.
6.30, which
Yeah,
is
6.30.
at the top of my page 601.
601, I'll put it.
Yeah.
So what we see here is it says this section, which is part 4 on service out, contains rules about service out of the claim form and other documents. And it doesn't distinguish between any particular types of claim form. Arbitration claim form obviously is a type of claim form, as are Part 7 claim forms, Part 8 claim forms. Therefore, a plain reading of it, an arbitration claim form falls within the wording of Rule 6.30a. Therefore, Part 4 on the service out provisions apply. Our fourth reason is as follows. If the respondents are right about their interpretation, then Rule 62.51 would in effect have to read, subject to paragraph 2a, the court may give permission to serve an arbitration claim form out of the jurisdiction only if, with the category cited below. But that rewrites the rules, or that rule, which of course doesn't refer to the term, doesn't use the term only. And the draftsman would, obviously we say, have inserted that term if Rule 62.5 was designed to be a complete code. And in fact, we refer you to the fact that there are other rules in Part 6 which do use the term only, and give as an example Rule 6.342. Yes, that has got nothing to do with service out. So, next the respondent's argument is that their interpretation is right because Rule 62.53 states that Rules 6.34, 0.35, 0.40 to 46 apply to the service of an arbitration claim form and makes no reference to Rule 6.36, which is the gateway into Practice Direction 6B 3.1. But again, that's wrong because all of these rules cited in 62.53 set out technical procedural rules that have to be complied with when service out is affected. So all that 62.53 is doing is applying those technical rules to a situation in which service out is affected under 62.5. It doesn't address any gateway issue. So the fact that it does not refer to Rule 6.36 says nothing about whether that rule applies to arbitration claim forms. And sixthly and finally, we refer to an extract from Briggs on Civil Jurisdiction and Judgments at 18.18.18. It's at tab 1 of section D. I won't give you the page number for obvious reasons. Now, 18.18 starts as follows. Provision of the service for the service of documents on a person outside of the jurisdiction is principally regulated by Rule 662.5 of the Civil Procedure Rules. That is then cited. Then towards the last three lines from the bottom, sentence beginning, however, there will still be some claims for which CPR Rule 62.5 does not apply, such as a claim raised against a person who is not a party to an arbitration agreement itself, or, exactly on point, where an anti-suit injunction is applied to restrain a party acting in breach of the negative stipulation, but where the seat of the arbitration is not in England. In those cases, if it is needed, permission may be sought and granted under Rule 6.36 and the practice direction. So it is direct authority we respectfully submit for the proposition we are making. Well, those are my submissions in relation to the respondent's notice on this point. Can I make two final, very brief, sweeping up points? The first is, it was brought to my notice, I think, because we were of the way the arguments went before lunch, that I hadn't made my Ladden Marshall application.
No, I've noticed that.
Yes. So I just ask your lordship to have a look, please, at our skeleton argument about that. It is set out on pages 75 to 78 of the core bundle, and we respectfully submit that the points there are self-explanatory. Then, in association with that, we would ask you please to look at Victor Prokofiev's report that we rely on, pages 3.1.
Yeah.
I'm now nervous about the supplementary bundle references, but in mine it's 3.12 to 3.18. And in particular, his unequivocal view expressed.
Section D, tab 1, and supplemental bundle 2. We've got Mr. Petrachowski's reply.
Yes.
At tab 6.
Yes. But what we rely on in particular.
You would accept, I take it, that if your application succeeds, then the respondents must be entitled to rely on Mr. Petrachowski.
Yeah, I do accept that. You'll see the analysis of Mr. Prokofiev from paragraph 2.1 onwards. It talks about the history of the arbitrage court and therefore where the terminology arbitrage comes from and what it relates to, etc., etc. And we rely, I think, just for the moment, on his conclusion at paragraph 2.5, which is the fourth page of his report, where he says it follows from his analysis above, therefore, that in my opinion, there can be no doubt that the correct translation of the phrase clause 9.15a, the Russian version of the mortgage agreement is the arbitrage court or commercial court, and it does not mean the court of a private arbitration institute. He then makes the point in paragraph 7 that the same phrase, arbitrage sudier, in clause 21.1 of the mortgage agreement in the Russian version is translated as commercial court.
Yeah.
Of course, that's very much a supplementary point because we say there's plenty of evidence anyway before the judge that contradicted the judge's finding that arbitration court meant arbitration tribunal. I'm sorry, I think Mr. Simpson had something. And the very last point is, I just want to clarify in case it wasn't clear. In relation to ground one, your lordships asked me at the start why English law was relevant, given that the dispute resolution clause in the mortgage agreement is governed by Russian law and the arbitration agreement is governed by Austrian law. So just to clarify, in case it wasn't clear, what we are concerned with is the interpretation of the arbitration agreement. That's the starting point. Common ground that we have been applying English law contractual principles to that because there has been no evidence of Austrian law on the contractual interpretation. Both parties below took the approach that English law principles should apply. Therefore, they do. On the basis of those English law principles, the starting point is, as is again common ground, the language and self-evident. The language of the arbitration agreement is mandatory, and that an event of default falls within the arbitration agreement. None of that is in dispute. From there, the only issue is, as far as English law is concerned, whether clause 9 of the mortgage agreement amends the arbitration agreement. That's the question. So that, and to justify the arbitration agreement being read otherwise than in accordance with its ordinary and plain language, i.e. mandatory. And in that framing, what the Moscow court has to say about the interpretation of clause 9 as a matter of Russian law is, we respectfully submit, irrelevant. The meaning of clause 9 is only relevant if it has the effect of amending the arbitration agreement, applying the principles of BNP. And our position is very simply that if you apply those principles correctly, the logical landing point is the presumption that the parties did not intend there to be overlapping dispute resolution clauses, and that is the answer to the question.
Is the question whether an English law clause has been amended by a Russian law clause a question of English law or Russian law?
Yeah, I thought you were going to ask me that. English law.
Well, obviously that's your answer, but what's the principle which makes that the answer?
Because the context, but because we are, two reasons. One is we are asking the question in the context of an English law argument, English law agreement. We are asking this in the context of how another agreement affects an English law agreement. But the second point is, there is no issue about how Russian law would apply to the interpretation of clause 9 and whether that will be different from English law. We've accepted that on its plain language read in isolation, it is capable of applying to an event of default. But we say once you apply the BNP principles, that falls away. My lords, unless there's anything else I can help you with, those are our submissions.
Thank you very much. Mr. Simpson, do you wish to add anything?
No.
Ms. Hutton?
My lord, subject,
Sorry, can you put your microphone? Sorry, thank you.
is it not on?
It just needs to be facing your folder, not the other way, thank you.
Subject to your lordships, I was going to deal with the grounds in the same order as my learned friend, but just subject to one point, which I was going to deal with a couple of initial points first, which came up this morning, in the hope that that might be helpful. And first of all is the foreign law point that my learned friend has just come back to, in the hope that it's helpful for your lordships to see how this developed. Your lordships would have seen the approach the judge took at paragraph 28 of his judgment. He dealt with it there. That is page 101. So it's core 10, 101.
Yep.
So he makes the point neither side, in particular to paragraph 28, although the mortgage agreement is governed by Russian law, neither side submitted any different rules of interpretation applied or reduced any expert evidence on that topic. I can show your lordships how we got to that point and hope that that's helpful. The skeleton that the respondents relied on below is at supplementary bundle 2, page 557. And paragraph 13, your lordships can see what we said there. So we said it's a question of construction as to whether the Moscow proceedings
Yeah.
are breach of the arbitration agreement. And then middle of the paragraph, FHM argues that the facility agreement and the mortgage agreement should be construed together, taking into account the overall scheme of the agreements, both as a matter of English law and Russian law. There's a reference there to Mr. Lim's evidence that was filed by FHM, because they're part of a single package of agreements entered into at the same time. However, as a matter of Russian law, just as under English law, the process of construction starts with the literal meaning of the words and expressions used in the contract. It's another reference to Mr. Lim's second witness statement. And the process of construction does not override the literal meaning of the words used. Reference to broader context in Article 431 relied on by Mr. Lim applies if the literal meaning of the relevant term and the relevant contract as a whole do not allow the content of the contract to be determined. There's therefore no basis in Russian law for a construction of the mortgage agreement which doesn't take into account the clear literal meaning of the terms. And that reflected the evidence in Mr. Lim's
Yeah,
witness.
although he wasn't giving evidence as an expert.
No, my lord, there was a bit of a to and fro about how far people should go in expressing.
He did set out some rules of interpretation.
My lord, absolutely. If it's helpful for your lordships to have the references, I can give the references.
Well, if it's common ground that they
Well, my lord,
nothing
it
turns
was
on
just
them.
so your lordships could see how it was addressed, the issue of Russian law. And we do say also that
Isn't the point not so much how you would interpret the clause if you were an English judge trying to follow Russian principles, which may be no different from English principles, but whether it is a question of interpretation of the mortgage agreement, in which case clause 21 says it's for the Russian court to do, not the English court.
Yes, my lord, I'm not sure I'm understanding properly the distinction your lordship's making, but I don't think I disagree. Is your lordship making the point that you start with the mortgage agreement?
Well, if you've got a question about what the
Whether it's
mortgage agreement means, then the mortgage agreement directs you to the Moscow court to answer that question.
My lord, yes, if we wouldn't, we don't, it is common ground though between the parties that the agreements are to be construed as a package. That's consistent as a matter of both Russian law and English law. And therefore, we wouldn't say that the mortgage agreement is to be considered on its own. But my lord, yes, the mortgage agreement, there's no reason why the process shouldn't start with the mortgage agreement and with the question of how it would be interpreted by a Russian court.
Okay.
My lord, yeah, it's being pointed out to me quite rightly that my lord, that's your lordship's approach is the approach we've taken in that my client brought proceedings in Moscow on the basis that the Russian judge would form a view, so we started at that end on one view, whereas FHM has obviously brought proceedings here. Just to finish on the question of relevant law, there is, in case it's helpful, there's a discussion in the BNP and TRM case, which your lordships would have seen, about a contract governed by Italian law, where it was a similar approach, where the principles were said to be no different to English law. We do say on that point, though, that it is relevant that the Russian court, as your lordships have seen, has reached the conclusion it has, which we can see in the Russian judgment, and it's relevant that supports our construction. Your lordships have seen that, but that's at pages 648 to 649 of the second supplementary bundle. And we do also say that the fact that that judgment has now been reached does give rise to further issues about comity and conflicting judgments, which I will come on to address very briefly at the end, subject to your lordships. The second point arising from this morning is my Lord Justice Lewison asked about the language in clause 9.1.2 of the mortgage agreement, which excludes certain provisions of the relevant Russian legislation. That is at page 183 of the core bundle. And the relevant provisions were in the bundle at first instance, and we have copies of them. Rather
Just explain in a sentence or two what they are.
My lord, it's rather as your lordship as your lordship expected. The article part 3 of Article 348 provides that foreclosure on the property pledged to secure an obligation is permitted in the event of systematic breaches of payment terms. That is, if payment terms are missed more than 3 times within 12 months preceding the date of filing a claim. So that's disapplied.
Right.
And a similar provision at part 5 of Article 54.1. So, my lord, in advancing their appeal on the construction clause 9.1.1, FHM put considerable weight on the principles set out by Lord Justice Hamblin in the TRM case. And your lordships will have seen we rely in particular on the 6th principle, which we say is needs to be given appropriate weight. But because of the emphasis FHM put on the starting presumption that Lord Justice Hamblin sets out, that each jurisdiction clause deals exclusively with its own subject matter and are not overlapping, we referred in our skeleton to a number of the leading cases. And we do ask your lordships to have regard to those. And we referred to the summary in Dicey and Morris, which if I could ask your lordships to look at that, which for summary of the position, that is at Authorities Bundle D2, page 636. It's the second Authorities Bundle.
Which case?
So it's Dicey, my lord, so it's the
Oh, Dicey.
Dicey. So it's tab 2 at the back of the bundle, page 636.
Yeah.
And it's afraid it's slightly small text. Picking up the paragraph at the top of the page, the second sentence, which, if any, jurisdiction clause applies to a dispute is entirely a matter of construction, and where English law governs the jurisdiction agreement, a matter of the application of established principles of contractual construction. It may be that the many decisions in this area have over-elaborated the application of familiar principles of construction, but the following propositions can be derived from them. We would rely in particular on these, on the second proposition. An agreement which is part of a series should be construed by taking into account the overall scheme of the agreements. Proposition 3, it's generally to be assumed that just as parties to a single agreement do not intend as rational business people that disputes under the same agreement be determined by different tribunals, parties to an agreement between them set out in multiple related agreements do not generally intend a dispute to be litigated in two different tribunals. And, my lords, we say that that supports our position, because in this situation, the construction we contend for means, of course, that there's no need for the respondents to go to the VIAC tribunal and then to the Moscow court, but can simply seek to have the dispute resolved and the relief they seek granted in one place in Moscow. Proposition 5 is that rational business people are unlikely to intend that disputes between them should fall within the scope of two inconsistent jurisdiction clauses. My lords, FHM suggests that that principle supports their position. We say, in fact, it doesn't, because the two clauses here, we say on their true construction, are not inconsistent, because we say on their true construction by allowing disputes to fall potentially within both, they enable disputes to be decided in one place rather than two.
How does that work here? If you have an event of default which leads to the whole sum becoming repayable,
Yes.
and the bank wants to enforce against the security which it has in Russia, so you say it goes to the Russian court to levy execution under the mortgage agreement, but that security may be inadequate for the whole amount of the loan, so it also wants a personal award against the debtor. So
Yes.
For that, it goes to Vienna. Is
Yes.
that right?
Yes, my lord, yes.
So the same question comes up in both, whether there is an event of default.
Yes, my lord, that is our position. But so our point is that it's this provision in the mortgage agreement, read together with the arbitration agreement, enables the foreclosure proceedings in Russia to be the sole set of proceedings if that is what if that's what the respondents choose to do. It's open to them to go to the Moscow court for foreclosure without doing anything else first. But yes, if they want different relief, further relief, then there is the potential of
And the scenario which I asked you about is not in any way unlikely.
No,
I might think
no,
it's a typical case,
no.
but therefore your submission is that in that typical case, what the parties have legislated for is that the very same issues, is there an event of default, if so how much is owing, will be litigated in two different fora.
My lord, yes, that's right. It is, of course, open to, and may well be the case, would perhaps often be the case, that the real estate security that has been provided might well be sufficient, and in circumstances where it could be enforced against effectively, then that may be, obviously it may not be, but it may be sufficient. But yes, if the parties have chosen to do that, then, my lord, we say that's, it's not uncommercial for the lender to decide that it would like a straightforward route to foreclosure in Russia, albeit that means there is also another set of proceedings in Vienna.
And in that scenario, is whichever tribunal loses the race bound by the decision of whichever tribunal makes its decision first? Or could you have a situation where, for example, Moscow says there is an event of default and Vienna says there isn't?
Well, my lord, as a matter of fact, I think it's inevitable either could happen. As to whether that would be the appropriate result, we would say no, assuming both parties had participated, as we say they should do in both sets of proceedings.
So there would be an issue of estoppel.
Oh, yes.
Applying which system of law?
Yes, my lord. I
If
don't
Vienna
know
if Vienna get there first, does a Russian court have a principle of issue estoppel by reference to some foreign tribunal?
Well, my lord, sorry. If the tribunal got there first, one would expect the route to be in terms of recognition and enforcement of the arbitral decision in the normal way. If, as seems to be the case here, the Russian court has made a decision first, both parties having participated in those proceedings and made submissions, then one would expect issue estoppel to apply.
Under Austrian law.
Yes, possibly. Yes, possibly.
That would be what
Yes,
presumably the
Vienna Tribunal would say yes, unless the Vienna Tribunal, yes, possibly the Vienna Tribunal having regard to Russian principles, but yes, in the first instance, Austrian issue estoppel principles. Yes. My lord, the point being made to me, and just to make it known, is that it's said in Lim 2 on page 283 of the supplemental bundle that FHM's sole source of revenue and assets is in Moscow. So just in context for the question my Lord Justice Mayles asked about whether this is a commercially attractive situation, in that case, it does make sense, we would say commercially, for the parties to have agreed a direct, effective route to enforce against real property in Moscow.
The facility agreement seems to refer to some Polish accounts, though.
Oh, my lord, I'll take instructions on that. I'm not sure. What Mr. Lim is FHM's witness. No, it's 283 in Mr. Lim's second statement. So paragraph 96. This point is being made in the context, I think, of the illegality arguments as being advanced, but in response to Ms. Tresova's point about ways to repay the euro debt. But 96, Mr. Lim says, FHM is a special purpose vehicle whose sole asset and source of revenue is the Moscow outlet. FHM receives all its business revenue only in Russia and only in Russian rubles. Therefore, the only way for FHM to make loan repayments from its Cyprus accounts was to transfer funds from Russia to Cyprus.
In terms of fragmentation, even if it would not be in your interest to go to Vienna, am I right in understanding on your case it would be open to FHM to do so?
My lord,
You commence Russian proceedings, they
yes.
say we'd like the event of default issue dealt with by the Vienna arbitration.
Well, my lord, if that happened, after we had issued foreclosure proceedings, there would be a question about whether that should in any way affect or delay.
Each tribunal would have to consider whether they should wait for the other,
My lord, yes.
but they might both say no.
My lord, that's possible. But my lord, yes. In the circumstances here, if after the respondents had commenced these foreclosure proceedings in Russia, FHM had brought proceedings in the VIAC tribunal, and got those underway, and then sought to stay the Russian proceedings, the respondents would point to the provisions of the mortgage agreement and say we don't have to wait for a decision from the tribunal, and we're entitled to proceed here.
But on your case, they would also be entitled to proceed in
Well,
Austria.
yes, subject to any application my clients would then make, depending on where we got in the foreclosure proceedings. So we could well say it's not appropriate for you to pursue these at the moment because these exact same issues are being considered in the foreclosure proceedings, which will result in a decision which we would say take effect by way of issue of stock.
And vice versa.
And vice versa, my lord, yes. So, my lords, just to finish on this section from Dicey and the relevant principles, there's then propositions 6, 7, and 8. Perhaps if I could just ask your lordships to read those. And by reference to proposition 7, FHM say that the disputes here, so whether there's an event of default and if so how much is due, are closer to the jurisdiction clause in the facility agreement than the mortgage agreement. But we say if one takes into account proposition 8, this is in fact a case where there is clearly a degree of overlap, intentionally so, which is something the court should have regard to in accordance with proposition 6, and that it's therefore that the judge, we say respectfully, was therefore right to conclude that the disputes fall within both clauses. And we've referred in the skeleton to the decision in Sebastian Holdings and Deutsche Bank, which I won't ask your lordships to turn up, but we do say that approach is instructive because it is very focused on the way in which the contracts in that agreement fit together, and therefore finding that the contracts provided for proceedings to be brought under each different agreement, even if that meant in different jurisdictions, because it was clear from the language that both the bank and Sebastian Holdings intended that result. And that's in particular at paragraphs 57, 58 and 59 of Lord Justice Thomas's decision in that case. other point that is flagged in or highlighted in Deutsche Bank and Sebastian is the point about the nature of the defence, which was referred to this morning. That's addressed at paragraph 61 to 63 of the decision there. And as your lordships will be aware, that's a point that was subsequently picked up by Lord Justice Hamblin in the BNP and TRM case, and the judge referred to that at paragraph 32 of his judgment. And we do rely on that point about the defence because we say that it can't be right that to say that if AO could pursue foreclosure proceedings if FHM hadn't raised yet any dispute over whether there was an event of default, but if it did raise that dispute before foreclosure proceedings were begun, that AO would have to go to arbitration first. And that seems to be the result of FHM's case on construction. So if they raise a dispute which fell within the arbitration agreement before foreclosure proceedings were issued, that would be what made the difference. And just before turning to BNP and TRM itself, we make a point on the authorities dealing with the presumption against overlap to say that those authorities usually do so by referring to the uncommerciality of such a result. So that's the decision of my Lord Justice Popplewell in the Mon Petroleum and Western Zagros case, which was referred to in Savona, and that's paragraph 19 of our skeleton. And we do say that our construction here avoids fragmentation in the situation we're in, at least, in permitting foreclosure proceedings without having to go to the VIAC tribunal. And it certainly doesn't produce greater fragmentation than would otherwise be the case, because in any event, foreclosure in Russia against the Russian assets would require proceedings before the Russian courts. That's entirely unsurprising. It was in Ms. Tresova's evidence, not contradicted by Mr. Lim, and it's borne out by the Russian judgment referring to the jurisdiction over the relevant property. So the effect of the judge's decision here is that for the purpose of permitting foreclosure, only one set of proceedings is required, rather than the VIAC tribunal proceedings first. Turning to BNP and TRM itself, although it might be said that there's a similarity between this case and that case because they both concerned two contracts with different jurisdiction clauses, we do say there's a relevant difference in the contractual structure between the two cases. So whereas here the mortgage agreement is all to do with enforcing rights under the facility agreement, which we say is something that's obvious but also borne out by the use of the same defined terms. It's a point my learned friend relies on as supporting his construction. We say it actually emphasises the very close relationship between the two agreements here. All to do with enforcing rights under the facility agreement, whereas in the TRM case, there was an overall financing agreement governed by Italian law with an exclusive Italian jurisdiction clause, and that provided for TRM to pay a floating interest rate against which the parties were to enter into interest rate hedging contracts. And then in fulfilment of that obligation, TRM entered into a swap transaction. If I can show your lordships the relevant part of the decision, it's tab 18, so it's Authorities Bundle 2, page 444. So the passage setting out the factual background starts at page 443, and then 444 explains the hedging transactions. And the swap transaction, which was the basis of the claim that was brought in the BNP and TRM case, that swap transaction, as is set out in paragraph 19 at the top of page 445, was on ISDA terms, including English law and a jurisdiction clause, and explains in paragraph 18 that it was the documents for that swap transaction which contained the representations relied on by BNP in bringing their claim in England. So the issue for the court, which is summarised at paragraph 3 in the introduction to the case, was whether BNP Paribas' claim for declaratory relief fell within the English jurisdiction clause in the swap agreement, not within the Italian jurisdiction agreement and the financing agreement. And so that was the background to the principles Lord Justice Hamblin set out. And just to note that there was a very similar contractual structure in the Savona case, which is also in the bundle at tab 17. That was another overall financing agreement and a swap transaction entered into under it. And there was a similar result in both cases. Your Lordships will have seen Lord Justice Hamblin's decision on the case before him at paragraphs 69 to 76. And my learned friends rely in particular on what Lord Justice Hamblin said at 76. This conclusion is further borne out by the implausibility of sensible business people agreeing inconsistent jurisdiction clauses and the presumption of mutual exclusivity. As discussed further below, there's no clear language displacing that presumption. On that, we say that that was very much, as is clear from the wording, this conclusion is further borne out. An additional point buttressing the decision the judge had already reached on the construction of the facts of that case. Second, we say it doesn't really assist FHM here because we say on our interpretation of the contracts here, the jurisdiction clauses are also not inconsistent because the parties have expressly provided for the situation the court is considering and the bringing of the foreclosure proceedings. Thirdly and relatedly, Lord Justice Hamblin made the point about no clear language displacing the presumption. Here we say there is such language.
Well, in BNP,
Yes.
I understand it, the claim was a claim for a declaration.
Yes,
The question was whether that claim fell within the English jurisdiction clause or the Italian jurisdiction clause.
yes,
I think we get that from paragraph
Yes.
3. Either tribunal would have been competent to consider whether to make that declaration. There's a question of which tribunal the parties had chosen to exercise that competence. Doesn't seem to be any suggestion that neither was incapable of doing it.
yes. I'm not sure what maybe the wrong issue. I'm not sure what the jurisdiction of the Italian court would have been to do that, given the ISDA documentation.
I mean, the point that I'm coming to
Yes.
is that in this case, the mortgage agreement concerns Russian realty situated in Russia, and the only court that could possibly enforce an attempt to realise the security is a Russian court.
Yes, my lord.
And so when Lord Justice Hamblin talks about the surrounding circumstances, that I would have thought would include the property, which is a subject matter of the particular agreement that requires to be considered,
Yes, my lord, absolutely. Yes. No, my lord, yes.
and the relief that's being sought.
My lord, yes. Well, we do. Sorry, my lord, I didn't mean to interrupt.
I'll put the point.
Thank you. No, we do. We respectfully entirely agree and adopt the point that, as we sought to say, because of the nature of this claim in Russia to execute against Russian property, the respondents are going to have to go to the Russian court to do that. And so the effect of the construction we're contending for is to at least streamline that procedure if the respondents are going to go down that route.
Because in many of these cases, what the parties are after is a monetary award.
My lord, yes.
And again,
Yes.
Either tribunal could consider it and make an award.
My lord, yes.
But here you've got the peculiarity that you're trying to
My lord,
enforce
absolutely.
property rights against real property situated in Russia.
My lord, yes. Yes, we are going to have to go to Russia. So, say there was every reason for the parties to agree to make that a straightforward procedure. And there are obvious commercial reasons why clients particularly would want to do that. I was going to turn briefly then to address some of the points specifically made in my learned friend skeleton and made in the submissions this morning. First of all, I should make clear that it's been said several times that it's common ground that the starting point is that the arbitration agreement is in mandatory and therefore exclusive terms for any dispute which falls within it. We don't accept that it's exclusive and mandatory when construed in the context of these agreements, as is obvious, I hope. My lords, on the points made by my learned friend Skeleton, as was clear from the submissions this morning, the central point my learned friends rely on is the point they make on clause 9.1.1 about the occurrence of an event of default. We've made our points on that in our skeleton. We respectfully agree with the decision the judge made on that, there isn't anything with respect to my learned friends that's been said in the skeleton or in the submissions which changes that position. It's said by my learned friends that there is nothing in clauses 9.1.1 or 9.1.2 that say how a dispute over whether an event of default has occurred is to be decided. But as the judge found, that's simply incorrect because 9.1.2 states that the mortgagee may levy execution immediately after the occurrence of the event of default in accordance with the terms and conditions of clause 21 of the agreement. And your lordships have seen that in the Russian judgment, that's exactly what the Russian court has done. It's gone on to decide that question. For the same reason, the submission that there's any question of unilaterally determining that there's been an event of default is misconceived because that's dealt with in clause 9.1.3, which requires a judicial process for the foreclosure proceedings. And there's still, in summary, we say, simply no explanation of the basis on which they say something else is to be introduced to add to the word occurrence or to require something else other than the occurrence of an event of default. And that point was raised repeatedly with my learned friends during the hearing at first instance. And there was no answer to it then, hence the judge's finding at paragraph 57 of the judgment, which is page 114, 410, 114, so where he held that 911 provides execution can be levied by judicial procedure as soon as an event of default has in fact occurred, as distinct from after a separate arbitral process has confirmed that to be the case. You also find that clause 9.1 applies if there's a dispute, including about whether there's been an event of default, and clause 9.1.2 makes clear that it can all be dealt with in the Moscow proceedings rather than first an arbitration and then the Moscow proceedings. And we also say that the fact that the consequence of my learned friend's submission is that most of clause 9.1.1 simply doesn't fall to be considered unless and until there's been a VIAC decision, which is a point that my learned friend made this morning, is a point that weighs heavily against the construction that's being advanced. That was in fact a point that was put to my learned friend by the judge below. That's transcript page 59, which is page 303 of the core bundle. And we say it weighs against the construction that that FHM are advancing. Another consideration which supports the judge's decision is what happens if the dispute is not over the occurrence of the event of default, but over instead just how much is due, which your lordships will have seen as the second dispute that's identified by FHM. And they say that that is also a dispute which has to be resolved by VIAC arbitration rather than as part of the foreclosure proceedings. And we say that's a particularly unattractive result commercially, because it seems to be said that even if there was no dispute over whether there had been an event of default, but simply over the amount that was outstanding, that would have to go off to the VIAC tribunal before foreclosure proceedings could be brought in Moscow. So that's even less persuasive. We say on the wording of clause 9.1, it's clear that we can levy execution immediately on the occurrence of an event of default. So as far as that second dispute is concerned, it's how much is due rather than whether there's been an event of default. So that, we say, does indicate a further problem with the construction being advanced. I was going to move on to clause 9.1.5 unless there was anything else which your lordships wish to raise in respect of the earlier parts of clause 9.1. This is the clause, obviously, which gives rise to the translation issue. Leaving aside the question of further evidence, our point is straightforward. We say that as a matter of construction, arbitration court here means arbitral tribunal. That makes sense as a matter of English language. And the fact that it's a reference to an arbitration tribunal makes sense in particular in the context of the clause itself. If I could ask your lordships to have a look at it for this purpose.
It's not just a question of the English language, though, is it? The English language has to be applied to something or other. And one would need to know about the Russian court system, wouldn't one, in order to apply the English language to the underlying facts? Yes, my lord, yes, there is relevant background. Yes. Some of it we say is very widely known, and the point I was about to make on the structure of 9.1.5, I'd say is perhaps an example of that. So there are three types of body identified in 9.1.5a, which is the relevant bit of the clause. So any court, arbitration court, or state authority. So looking simply at the language of the English version here, given that court
the first reference to any court is not limited in any way, so we said any court, then the type of Russian arbitrage court, which my learned friend is saying is the meaning of the second category, would naturally fall within that first category. It's not excluded from it. So we say that that construction would be surprising because it's simply not necessary to add a further layer of Russian court at that point.
Well, you don't need the first court at all on that line of argument, do you? Because it's a state authority.
My lord, I'm not sure I would accept that was a usual use of language by a draftsman. I think if one's identifying decision-making bodies, there is, I would respectfully submit, a fairly normal distinction between a court on the one hand and a state authority of a different type. For example, one would expect a court to be independent. State authority, one wouldn't usually. Whereas arbitration court does seem more naturally to fall within a court category.
Well, we know, don't we, from the Russian judgment that you need some sort of license to,
Well,
or at least the judge said you needed a license to
Yes.
start these proceedings.
Yes.
And that doesn't come
Yes.
from a judicial body, it
No.
comes from what
No,
you
well,
might
that's-
loosely call a
that's
state
said-
authority.
that's state or the central bank, my lord, yes. Yes, I understand, yes. So, my lord, we do say that it would be odd, given that a distinction has been made here between court and arbitration court, for that to be a reference to a particular type of.
So you say in effect there's a hierarchy of judicial bodies, quasi-judicial bodies and non-judicial bodies.
My lord, I didn't quite suggest it was a hierarchy, my lord, but yes, I was saying this. The second category is, one would expect something that doesn't naturally fall within the first, and on our construction that makes sense. Yes. And we also make the point on this clause that if it doesn't mean what we say it means, it is rather difficult to see what part it was intended to play. My learned friends, I think, accept in their skeleton, that's paragraph 43, that it's simply surplusage, but it doesn't appear to be a very normal boilerplate type clause. So we do say that would be surprising. And insofar as my Lord Justice Lewison was suggesting that the recent decision of the Russian court suggests that the type of approval that is said to be required is the kind of thing that's considered by the state authority provision in 9.15a. We would submit that's not right. That can't be the type of approval being required, because that's as far as one can tell from the judgment, that's a sanctions related requirement, which the parties clearly couldn't override by a provision of this type. So it's not clear that could be the type of provision that's being referred to. To address the new evidence application quickly, our first point is that, as your lordships will have seen, this isn't a case of an English translation of a Russian original document. The mortgage agreement was executed in both English and Russian language original versions, so it's not a translation of a Russian original, there is no provision that the Russian language version is authoritative. If I can show your lordships the relevant provision my learned friends rely on, that's at page 187.
That tells you that notices have to be in Russian.
My lord, yes, yes. So it's page 187, and it doesn't have the effect that it's said to. So we say, for the purposes of the application, those are our key points as to why we say it wouldn't be likely to have a sufficient effect to justify permission to adduce it. We also say that FHM had ample time to adduce it before the first instance hearing, and that the judge was right to say that the point was clearly in play, at least since the first witness statement Ms. Tresova made, which was dated the 10th of September, and that there was therefore ample opportunity for it to be responded to then if it was thought that there was a need for evidence to address the point that she was making.
But I think there may be another point here as well. As you say, there are two versions of this agreement, one in English, one in Russian, and one assumes that they are equally authoritative. The Russian agreement has been placed before the judge in Russia, and I think she refused to look at the English agreement on the ground that the Russian agreement was the relevant one for her. I'm thinking I'm right.
I think she said she wasn't. She decided against FHM on this point.
Yes, that's exactly it.
Yes.
She's already looked
Yes.
at what this
Yes.
arbitration of the suit means, and she's agreed with your side.
652.
Oh yes, it's 652 in the supplemental bundle. And it's about 2 or 3 paragraphs, I think, up from the bottom of the page. The respondent's argument that the court misinterpreted and mistranslated the provisions of the loan agreement, mortgage agreement is rejected, as the case file contains versions of the agreements translated from English into Russian signed by all parties.
I thought there was something about translation. Sorry, where is it?
Well, it's about 3 paragraphs up from the bottom of 652.
What's the internal page number?
Sorry, 15.
15.
Oh, there's an official translation and a machine translation in the bundle. That I don't know if that's causing issues. H3 is a certified translation, so that's the one I was referring to. It shouldn't affect the page numbering. But a couple of paragraphs above that, you all should see she's considering clause 915. So we have the complication. This also was a potential translation issue here as well, but the parties agreed that would.
Yeah.
my lords, if your lordships haven't had the opportunity to look at it, if I could ask your lordships to look at what Miss Tresova said about this. It's supplemental bundle B3, page 239. So that's the first supplemental bundle. So in paragraph 26 is the first, there are two passages where the point is made. Paragraph 26 starts on page 246. So your lordships can see there that Ms. Tresova sets out the language of clause 915A and then directly states that it expressly allowed AO UniCredit to proceed straight to levy execution and didn't require AO UniCredit to commence any other proceedings as a prior step. And of course, there is a specific reference to an arbitration tribunal later, but of course, the only issue that Ms. Tresova is addressing here is this is in answer to the anti-suit claim. So the only point in issue is whether AO is obliged to go to arbitration first. And the second relevant paragraph, or relevant section, is paragraphs 36 and 37 on pages 251 and 252. So again, a reference 36C to clause 915. And Ms. Tresova there uses the language of obtain a decision of any court, arbitration, court or state authority. And then in paragraph 37, she says, therefore, under the mortgage agreement, AO UniCredit was entitled to proceed to levy execution without first obtaining a decision from an arbitral tribunal. So again, using the language of obtaining a decision, which is a clear reference to 915A. So we respectfully say the judge was entirely right to say the point was clearly made in evidence. As I said, that witness statement is dated the 10th of September. In the result, FHM's evidence in reply didn't have to be filed until 15th of October. So there were 5 weeks between those two rounds of evidence. And Mr. Lim didn't challenge what Ms. Tresova said about 915 and arbitration tribunals. That's what the judge found in paragraph 59 of his judgment, which is page 115 of the core bundle. And FHM now seek to say, without evidence from Mr. Lim, that it's simply absurd to suggest that he understood arbitration court in clause 915 as including an arbitration tribunal. They say to any Russian lawyer it could only mean an arbitral court. So we say that's simply wrong, and it's now very clear from the Russian judgment, among other things, that that's not right. And the lordships would have seen, as set out in our skeleton, that although it said that this point was only made by us in the skeleton for the first instance hearing, the point wasn't in fact raised straight away by FHM in submissions. It was only when the judge started asking questions as to whether they didn't accept that 915A included arbitration tribunal that the point began to emerge during the transcript. So we say the conclusion your lordship should draw is that it hadn't occurred to FHM to dispute this point until the judge raised those questions. The point was clearly made in Ms. Tresova's witness statement. There was ample time to deal with it, and therefore FHM shouldn't now be permitted to adduce new evidence on the point.
You make the point in your skeleton argument that it was agreed that the Russian version of the agreement should not be included in the bundle
Yes.
of the hearing below. You made the submission that the Russian agreement and the English, the Russian language agreement and the English language agreement are equally authoritative.
Yes.
If that submission is correct, is the evidence that FHM wished to adduce admissible at all? It could only be relevant if I were translating
My lord, yes.
the Russian
My
agreement.
lord, yes.
If
yes.
your submission is that they are both equally authoritative,
My lord,
why
yes.
does it matter?
My lord, yes. We would say that must be the correct approach. There is the only thing that's been pointed to is weighing one against the other, is the notice provision, which clearly doesn't do what it submitted it does. There's neither side have identified any principle as to why in those circumstances either should take priority. So my lord, yes, in those circumstances we would say primarily it simply isn't admissible at all. My lord, in light of that, I will move straight on to ground two rather than make any points. If your lordships don't accept that submission, then we have filed evidence from Mr. Pettikovsky, which your lordships have, and we've also included in the bundle a decision which further supports the point being made on translation. That's the A and B decision, where the English court had to consider a similar phrase. Similar was moving on to ground two of my learned friend's appeal.
Can I just ask you something?
Yes.
On point of detail. It arises in the context of being able to enforce speedily. I understood that the way clause 9 works is that 9.1.4 restricts the form execution to public auction in a single lot. That means single lot of all the mortgage property, presumably. We've got a definition of, I think, 7 or 8 different pieces of property at different locations, like a gas pipeline,
Yes.
so on. And I think there's a provision for properties to be actually become mortgage property. And then that has to be to public auction. We see at the end of 9.1.4 with a starting price. And the
Yes.
starting price in the definition says it's got to be 80% of the market price. The market price, market value.
Yes.
And the market value at 9.2 has to be based on an acceptable valuer's report. Acceptable valuers are accountants prepared up to 3 months before the date when the court is petitioned to levy execution. So does that mean that if AO want to execute under this mortgage agreement, they've first of all got to get one of the accountants to value all the properties? Because they've got to identify what the starting price is in order to be able to get the market value before the date when a court is petitioned to levy execution under 9.2.
I'll take instructions on that. I'm afraid I don't know. It might well be that there's an ongoing obligation to have reports as to value at intervals. But I will. Well, I'm afraid I'll have to come back to you. So, my lord, line 2, the relevant part of the judgment is paragraph 79 to 81, which is pages 120 to 122 of the core bundle. Paragraphs 82 to 83 concern a point raised below that isn't pursued on appeal. And your lordships will also have seen that 79 reflects the fact that FHM originally ran a point on the transitional provisions concerning section 6A of the Arbitration Act, the effect of which would have been that the arbitration agreement was governed by English law. So that was the initial primary case. That was abandoned. So that left FHM with the issue that the arbitration agreement not only provides for arbitration with a foreign seat, but an arbitration agreement which isn't governed by the law of England and Wales. Just to stand back at that point for a moment to consider where that puts this case on the spectrum. As your lordships have seen, Kamenogorsk was Kamenogorsk was the case that made clear that the grant of an ASI in this situation is to protect simply the negative right under the arbitration agreement. And therefore, Lord Mance explained there's no need to bring an arbitration claim. So we rely on that, and we say that shows that the claim for an ASI is not properly understood as to do with vindicating rights under the matrix contract, because there's no necessary intention to pursue the arbitration that might be brought, because that's the positive obligation, and this is to do with vindicating the negative right. And at the time of Kamenogorsk in 2013, it was clear that the English court would grant an anti-suit to protect arbitration with an English seat, and Lord Mance emphasised that was a well-established jurisdiction which was exercised by the English court pursuant to section 37 and hadn't been abrogated by section 44. As your lordships have seen from Ruschem, that is a development because although the arbitration agreement was governed by English law, that was part of the decision in that case. The seat of the arbitration wasn't in England and Wales, the seat was in Paris. And that was the reason why the judge at first instance held the English court didn't have jurisdiction to hear the claim. The Court of Appeal overturned that decision, and the Supreme Court upheld the Court of Appeal's decision that there was jurisdiction. And if I could ask your lordships to look at Ruschem again, at paragraph 92, which is page 540 of the Second Authorities Portal. Paragraph 92, my lord.
82.
92.
92.
Sorry, I picked the wrong one. And this is the part of the explanation of the principle that my learned friend was referring to earlier. So in a case as here, where the arbitration agreement was governed by English law, permission to serve out under the contract gateway should be permitted unless, in the opinion of the court, the fact that the seat is or is likely to be outside England and Wales makes it inappropriate on the facts of the case to exercise the court's jurisdiction to grant relief aimed at enforcing the arbitration agreement or supporting the arbitral process. And this test should be applied consistently with the principle discussed above, that a strong reason needs to be shown as to why in the particular circumstances the court ought not to exercise its jurisdiction to restrain a breach of the parties' contractual bargain. And then there are two paragraphs which we would emphasise in the context of the purpose of the gateway in the case here. First of all, paragraph 75, which is on page 535. And your lordships have seen this already this morning. It's the statement, my Lord Justice Popplewell in the Enker decision. It's desirable that parties should be held to their contractual bargain, but we would emphasise the second part of that statement, by any court before whom they have been or can properly be brought. So it's all subject to the question, as your lordships have seen, as to whether the court can properly take jurisdiction. And then again at 83, the same point is emphasised because here Lord Legate says it's unnecessary to express a view in this case on whether it will always amount to a sufficient connection to justify intervention by the English court. That the English court has personal jurisdiction over the defendant. And then the last sentence, there is a substantial connection with England and Wales in the fact that the contractual rights which UniCredit is asking the court to enforce are rights governed by English law. So the personal jurisdiction is a necessary but not a sufficient connection. So the existence or the court's ability, therefore, to exercise the power being discussed in the Ruschem case, therefore, all depends in a case like this on this Brian 2 point about service out. So it's certainly not a small procedural hurdle along the way. It's a substantial hurdle. And the fact pattern here of a foreign seat and an arbitration agreement not governed by English law is a new one. My learned friend emphasised that the wording in respect of a contract has in some cases been given a wide scope, and we don't disagree that is clearly appropriate in some situations, and the judge expressly recognised that at paragraph 35. He cited Aquanta, he cited Greenwood and McLean, and at paragraph 36 he cited the two Alban and Nasr decisions that were relied on by FHM. But we say the appropriate starting point here is that the claim is a claim for an anti-suit, so it's all to do with the negative obligation in the arbitration agreement, as Lord Mance explained in Kamenogorsk. And the claim is not about enforcing rights under the matrix agreement. So it's not a claim in respect to the facility agreement in that sense. So we say it is or is to be treated as a two-contract situation, and that in a two-contract situation, the question is the one that was identified by Lord Justice Hamblin, as he then was in Cecil and Byatt, which is in turn referred to in the Aquanta passage, which the judge cites at paragraph 35 of the judgment, namely whether the facility agreement needs to be referred to and relied upon. And in support of the fact that this is or should be treated as a two-contract case, we rely on the following matters. First of all, the point I've made that the anti-suit claim is to do with enforcing a negative promise, and that there's no obligation on the claimant to start arbitration proceedings. So we say that's the first point. The claimant for an anti-suit is not bringing a claim in relation to the underlying agreement at all. And that's the position here. And secondly, we say it follows from the logic of the gateway itself. The relevant gateway provides that if the other relevant requirements are satisfied, the English court will have jurisdiction where the claim is in respect of a contract governed by English law. And it follows that if the claim isn't to do with a contract governed by English law, the gateway doesn't apply. So in other words, the line of distinction between the facility agreement here and the arbitration agreement, which makes a difference, is the fact that they are governed by different applicable laws, and that's the very criteria the gateway is concerned with. It's not a unimportant distinction, it's the key distinction as far as the gateway is concerned. It's the purpose of the gateway. And we also rely on the fact that the distinction between the governing law of the facility agreement and the governing law of the arbitration agreement is not only recognised by, but in fact results from a recent statutory provision, i.e. Section 6A of the 1996 Act. And we say that the existence of that provision supports our case that this is a real distinction which shouldn't be glossed over as unimportant or insignificant. By Section 6A, the legislature has decided that where the parties do not expressly agree on governing law of the arbitration agreement, it's not the governing law of the matrix contract, but instead the governing law of the seat. And against that background, we do say that the result FHM contends for is clearly wrong, simply inconsistent. Fourthly, we rely on the fact that the parties in the Ruschem case and the courts which considered that case all proceeded on the basis that the relevant contract was the arbitration agreement and not the matrix contract. And the judge sets out the treatment of the issue at paragraph 37 of the judgment. If I could ask your lordships to look at that, because it's suggested by my learned friends in their skeleton that the judge may have misunderstood the extent to which the point arose in that case, but we accept that this point wasn't argued in the case, but if it was a good point, we say it's very surprising that throughout the course of the case, nobody did make it, because it would have been a shortcut in avoiding the issue as to the governing law of the arbitration agreement. So at first instance, as the judge sets out in paragraph 37, page 105 of the core bundle, at first instance, Mr. Justice Tier set out the gateway and said, thus, the question is whether the arbitration agreement is governed by English law. In the Court of Appeal, my Lord Justice Males said in terms at paragraph 40 that because of the principle of separability, the contracts on which the bank relies are not the bonds, which are expressly governed by English law, but the arbitration agreements contained within them. The issue, therefore, is to the governing law of those arbitration agreements. And then in the Supreme Court, the bank did identify this point, but they didn't pursue it in argument. And Lord Leggett says in the passage that's set out at the bottom of 105, that if the argument had been thought to have any merit, it could have been pursued below, and he would have refused permission if the bank had wanted to pursue it. So as we say, if FHM's argument is a good one, it is surprising that the point wasn't raised at any point in that case. And so we say that also rely on the fact that's an accurate summary of the position in the Ruschem litigation. So the suggestion in my learned friend Skeletons, it's footnote 21 on page 43, that the judge was in some way incorrect as to what had happened in the Ruschem case. That's clearly wrong. course, in Ruschem, the reason why the point about the governing law of the bonds had perhaps become more pertinent was the fact that Section 6A was about to be introduced. So it may be that the bank thought it was something the Supreme Court might want to take into consideration. We rely, and this is the point at paragraph 43 of our skeleton, we rely on the fact that the statutory change at section 6A provides further good reason for the distinction between the two agreements in terms of the gateway at paragraph 3.16c, because the parties are now statutorily deemed to have chosen Austrian law as the law of the arbitration agreement, as well as it being the law of the seat, and therefore the relevant supervisory law. So although the English court will have jurisdiction to make orders under section 44, so taking evidence, granting interim injunctions, and those kind of applications can be served out pursuant to CPR 62, a claim for some other remedy, which is the ASI gateway in 62, doesn't apply unless England is the seat and therefore has supervisory jurisdiction. So that's why any ASI application has to be served out under Part 6. And we do say that change may go some way to explain why the position may have changed since the decision in Yule, which was a decision.
By that change, you mean section 6A?
Yes, yeah. Yes. Sorry, which is a decision from 2000, and Yule also predates the Court of Appeal's consideration and identification of the two contract situation in Cecil and Barrett and the Global 5000 cases. It also appears that in Yule, it wasn't a necessary part of the decision. In that case, there was an issue about an EJC and also the question of whether it was governed by English law. And Mr. Justice Aikens, as he then was in that case, said that the governed by English law criteria was sufficient, but it didn't. The case didn't actually turn on that. FHM seemed to suggest that the judge fell into error in this case by relying on what was said in Global 5000 because it was obiter. But we say it's, on any view, clearly a very helpful discussion of the relevant issues. Lord Justice Ricks expressed a view because he says the point was fully argued before the court. And as your lordships will have seen, the case involved discussion of the leading cases. FHM say that it's distinguishable because here there's no dispute about the validity of the arbitration agreement, as there was in the case before Lord Justice Ricks, but on the basis he was considering this issue, he was assuming that the agreement was in fact valid. So it doesn't seem that that's actually a real distinction. And the fact that Global 5000 is, on any view at least, extremely useful is borne out by the fact that it's cited extensively with approval in the passages of Quanta, which my learned friend relies on and showed your lordships. And it's also cited by Dicey, as the judge sets out in paragraph 38 of his judgment, for the proposition, for authority for the position on two contract cases. finally, my lords, we do say that if the approach urged on your lordships by FHM is adopted, it would leave a rather extreme position. It's effectively eating into, or rather maybe extending is the best way to say it, given that Ruskin recognises the existence of an extended power by the court to grant anti-suit injunctions, where there is personal jurisdiction over a defendant, to then add to that an easier method for the court to assert such personal jurisdiction in a claim such as this would be a significant widening, and would, we submit, possibly lead to a misapplication of the principles that have been set out in the Ruskin case. If I can ask your lordships to look again at paragraph 93, because that's the presumption which Lord Legate said in Ruskin should now be applied in the case of a grant of an anti-suit. And I think this is at least related to the point that my Lord Justice Popplewell was raising with my learned friend just before and after lunchtime. As Lord Legate explains in this passage, he says that the question of whether England and Wales is the appropriate jurisdiction should be applied consistently with the principle discussed above. This is the end of paragraph 92 at D to E, that a strong reason needs to be shown as to why in the particular circumstances the court ought not to exercise its jurisdiction to restrain a breach of the party's contractual bargain. And then he says at 93 that in the context of the type of case before him, he doesn't consider that the rule 637(3), which requires the court to be satisfied that England and Wales is the proper place, precludes this approach. Those words are capable of being read in a case of this kind against the background of a presumption which treats the courts of England and Wales as the proper place in which to bring the claim for an anti-suit, unless the fact that the arbitration has a foreign seat makes it inappropriate to do so. So that is an extensive approach to considering the proper forum question, and we say that if the contract gateway that your lordships have to consider on this appeal is given the very wide interpretation in a case of this type that FHM is proposing, then there is very little restriction at all on the court's power to do so. And my Lord Justice Mayles asked about whether there was any geographical connection at all, and it's the rules are structured so as to require a connection in terms of governing law, and where the claim is concerned with an arbitration agreement which isn't governed by English law, we do say it would be inappropriate for this gateway to be used in that type of case.
Is that what you want to say on ground 2?
My lord, it is, yes.
In that case, you can deal with the remaining grounds tomorrow at 10:30.